If you've been sued by a debt collector, you're likely going to be facing a motion for summary judgment in the very near future. In this video, I'm going to do my best to simplify how it is you can respond to the motion for summary judgment so that you don't lose your lawsuit. But if this is your first time here to my YouTube channel, go ahead and click subscribe. Each week I put out new videos that show how you can deal with serious debt problems. Go ahead and click that little bell so that you don't miss out. Okay, in this video, I'm going to tackle a topic that can be pretty difficult and is one of the biggest hurdles that most people have when it comes to trying to deal with their debt collection lawsuit. So if you've been sued by a debt collector or a junk debt buyer, somebody who's saying that you owe them money, you're likely going to get a summary judgment motion filed against you. This is because you filed an answer to the complaint. You avoided the default judgment, which was an awesome move, but they are going to file this motion for summary judgment to avoid trial. One thing that a lot of people don't understand is they think, okay, if I file my answer with the court, then at that point, they're going to set a trial date, then I'm going to be able to come in and share my side of the story. That's not how most of these things play out. Usually what happens is the debt collector files a lawsuit, you file your response, and then fairly shortly after that, they file a motion for summary judgment that basically says, hey, judge, we don't need a trial. Just look at our documents and tell us if we win. Now, a lot of people make the mistake of not responding to the summary judgment motion. And in most jurisdictions, if you don't respond to the motion for summary judgment, the court is to interpret that as you agreeing with their motion, and they go ahead and grant it. Not only that, once motion for summary judgment is granted, your case is over. Judgment is entered. You're not going to get your day in court. Next thing you know, you're going to be facing wage garnishment, bank levies, possibly even having to file bankruptcy over it. So the motion for summary judgment is the most important step. First thing, you have to file the answer. You did that, which was a great job. But now if they file a motion for summary judgment, you must respond to it, and you must respond to it substantively. This response is much different than the answer to the initial complaint or petition that the creditor filed with the court. In the answer, what you did initially, really you were just admitting or denying what their allegations were. In responding to a motion for summary judgment, you've got to come in and respond directly to their evidence, to their facts, and show the court that there is some type of dispute as to what they're alleging. You've essentially got to show why you should win and not they win. You can't just sit back and admit or deny or not respond. You're going to run into a lot of problems with that. So let's kind of try to break this down of what they're trying to do and what you can do in drafting a response. And admittedly, this is one of the most difficult parts to respond to. If you're doing this on your own, you're probably a little confused as to what to do. So I'm going to try to make it clear, but this is the debt collectors know this. They know that most pro se or pro per people who are representing themselves, this is where they struggle in dealing with the lawsuit themselves. And they know that this is where they're going to get judgment against most people. So when you think of summary judgment, the first thing you got to do is you got to know the rules. Now, summary judgment is based on the rules of civil procedure. Each state has their own rules of civil procedure. There's a rule, and it's generally 56. Rule 56 is the federal rule, and most states base theirs off of it. A good resource for you to look up the rules of civil procedure in your state is Google Scholar. I just recently did a video on how you can use Google Scholar to find legal research, to find statutes. There's also the Legal Information Institute, which is put out there by Cornell Law School. And it's a free resource that provides you with a ton of information on different statutes. You can actually read what the law is. And so you can read through there and see exactly what it is that they have to do. That'll also show you how much of response time you have. Usually it's somewhere between 10 and 30 days, depending on which state you're in. But as far as the content of what you are responding to, summary judgment is only appropriate. It should only be granted if basically the facts are not in dispute. Basically, if the parties are saying, look, judge, we basically agree on what the underlying facts are. We just need you as the judge to go ahead and apply the law to our specific situation and tell us who wins. If there are factual disputes, that's when the court should say, no, we're not going to grant summary judgment. We're going to take those factual disputes to trial, where either a jury or a judge will make a determination on who's correct between those two fact patterns. Now, in cases of debt collection, particularly junk debt buyer cases, right from the get-go, there is a factual dispute. Because let's say that you were sued by Midland Funding. Midland Funding comes in, they file their lawsuit. They're saying, hey, we want you to pay us money. And a lot of people are saying, why should I pay Midland Funding money? I don't even know who this company is. I didn't agree to pay them any money. I didn't sign a contract with them. They didn't loan me any money. So why should I write a check to them? So there's that initial factual dispute just right out of the gate if you're dealing with a junk debt buyer or a debt collector of some sort who has filed a lawsuit. Now, so that can be your first factual dispute. You've got to raise this issue that, hey, Judge, right out of the beginning, there is a dispute between the parties as to the facts because I don't think I owe that company any money. And they have to prove that I owe them money. Otherwise, they shouldn't be able to get a judgment. So that's the first factual dispute that you need to raise is who is the actual owner of the account because they didn't loan you money again and you didn't agree to pay them any money. Second thing you need to look at is the amount owed. How did they calculate the amount owed? Let's say that they did prove that they own it, but is there a factual dispute as to how they calculated that dollar amount? In many debt buyer cases, they'll come in and just in a conclusory way say, hey, here's the amount owed, Judge. Just look at this last statement, and they'll just have one statement there. There's no discussion of what the interest rate was, how payments were applied. There's none of that information, and it's usually because the debt buyer doesn't have that information. But that's another factual dispute you can raise, particularly if you feel like there are payments that you made that weren't applied, or if they're just suing you for an amount that's just nowhere near what the card was. You know, I routinely see credit cards where the initial limit on the credit card was $2,500 and they're being sued for $6,000. But there's no explanation of where that came from, how the interest was calculated, and all those types of things. So you need to go through their motion for summary judgment, and then in your response, you need to point out that there are factual disputes. There are facts that are in dispute between you and the debt buyer that need to go to trial. So summary judgment is not appropriate. That they need to go to trial to be able to establish who the correct owner is and what the dollar amount owed is. And part of this is going to require you to dig through the documents a bit. A big place where you can find discrepancies and a real lack of information is often to their motion for summary judgment, they're going to file what's called a bill of sale and assignment. And this is where they're saying, hey, this is the document that gives us ownership rights to your account. The thing is, if you really start digging deep into it, you'll see there's not a lot of information in there. It's just very generic. It'll say that Citibank sold a pool of accounts to Midland Funding or to Portfolio Recovery Associates or LVNV. And then it will say the accounts are attached on Exhibit A. You turn over, there is no Exhibit A. Or if there is an Exhibit A, it's been totally redacted. Or if there's sometimes they put a spreadsheet, which is clearly not what Exhibit A, but they're claiming this is some extraction that they got from the actual Exhibit A. But they don't actually provide the document that they say gives them the information or the ability to be able to sue you. So those are the types of things you need to do is go through and show the court and back up your arguments with evidence. Saying not only am I just saying that I don't know Midland Funding or Portfolio Recovery or Unifund, not only am I not saying that I don't owe them any money, there's nothing here in the evidence that they're providing you as the judge that would support that. And so you've got to really point that out in your motion. And I can tell you now, what I do a lot of times when I'm responding to summary judgment, I will literally cut and paste portions of their evidence right into my Word document. You know, I'll do a little screenshot of the bill of sale and assignment, and I'll point out to the court, look, there's nothing here that says that my account was transferred. So those are the types of things you need to do. It's also very helpful usually to attach an affidavit to the response that you're filing with the court that states that you don't owe Midland Funding any money. Now, it's important you've got to always be truthful when you're submitting documents like that to the court. But in most cases, unless they have proven it to you and you have some kind of acknowledgement on your part that they own it, you could put in there, hey, they didn't loan me money. I didn't agree to pay them money. I don't believe that I owe this debt collector any money. That puts a sworn statement before the court where you're attesting I don't owe this company any money because I didn't borrow any money from them. Again, you're submitting an affidavit or a declaration to the court under a penalty of perjury. So there's real consequences if you're not going to be truthful. You've got to be truthful in everything you're submitting to the court. But if it is truthful that you didn't loan any money from the debt buyer and they didn't loan you any money and you didn't agree to pay them, that's okay to put in an affidavit and go ahead and submit that to the court. So once you have gone through and line by line just picked apart the evidence and the allegations and showing that there are factual disputes between the parties, then you can get into an area where you can actually object to certain parts of their evidence coming in. Now, I am going to say this. I'm not going to go into a lot of detail as far as objections to evidence. That's probably a topic for another video. But the rule that you need to look at, it's in the rules of evidence. And again, in most states, the numbering is fairly similar. But it's the hearsay rule, the rules of evidence, in Rule 803, subsection 6. This is called the business records exception to the hearsay rule. And essentially what this is, the problem that the debt buyer has is that often they're submitting documents that were created by another entity. So like my example before, let's say the Citibank is sold a pool of accounts to Unifund. Often in the summary judgment setting, Unifund's going to have an affidavit from one of their own employees there trying to testify about documents that were created by Citibank. Well, Rule 803.6 states if you're going to submit documents in support of a motion for summary judgment or a trial or anywhere else, that the person who's testifying about those documents, they have to authenticate them. They have to be able to say how the document was created, what the process is, how they retain and store those documents. That's not what you have in debt buyer cases. You typically have a debt buyer witness, say again Unifund, a Unifund employee trying to testify about documents created by Citibank to try to establish that they're authentic, even though they will fully admit they don't have any information or any training on how those entities created those specific documents. So the first thing you need to do, obviously, is to raise the factual issues and the factual disputes to show the court that the parties are not in agreement on the underlying facts and that you need a trial. Summary judgment's not appropriate. You need a trial, so their motion should be denied. And I can tell you also there's some case law in most states. You may need to do a little bit of research over at Google Scholar on this, but most states, the case law states that the judge is to essentially give you the benefit of the doubt as the person whose summary judgment is being filed against. So the judge is supposed to look at this and say, is it plausible what the defendant is saying here, that possibly that their account wasn't included in this particular transfer? And if it is possible, and it is plausible because, frankly, the debt buyer has not included the information that they need to support that, then the court is supposed to deny the motion for summary judgment. Basically, they're supposed to err on the side of caution and have the case go to trial. So those are some really quick tips and points to help you as you're drafting this. I know this is not an easy motion to draft a response to, but I actually have a kind of step-by-step course that'll walk you through this. I'll put a link for that down in the notes here below the video if you want to take a look at that. That can be helpful. It's a lot more detailed and frankly covers a couple hours worth of videos where I kind of walk you through what it needs to look like. But the important thing is you've got to respond to it, raise those factual disputes to the court, and let them know that there are things that need to be resolved at trial, that you want your day in court. That's going to put you in a chance to win your case, and at a minimum, it's going to put you in a better chance, in a better position to try to settle the case. Appreciate you watching today. Again, I'll put the link in the notes for the course if you want to take a look at that. Appreciate you watching.